Hi, I'm Micah Clark. Thank you for joining us today. I have a special guest with us because I'm going to be gone this week, and one of the speakers that we have at a conference coming to Indianapolis called the Southern Social Conservative Conference is a good friend of mine from American Family Association, our national office. He's the Director of Government Affairs for AFA. He also works with American Family Association Action. He has a long history of political involvement, public policy work. It's great to have Dr. Jameson Taylor with us today. Jameson, it's good to see you.
Hey, thanks for having me on the show today, Micah.
Well, over the years, you and I have talked a lot about one particular issue that I wanted to talk about before we get to what you're speaking on the conference later this week, and that is you've been a real expert, at least to me, and I really appreciate your help on public policy, on obscenity issues, protecting children from the culture. And just 2 weeks ago, we had a major Supreme Court ruling in a Texas lawsuit that dealt with protecting children from pornography websites. And Indiana was watching this closely because we had passed a law that I testified on a couple times 2 years ago, Senate Bill 17, that required pornography or adult websites. I don't like using the term adult websites, it's pornographic websites, but requiring them to use age verification software to prevent minor children from being able to access that. Can you tell us a little bit about the background of that? I know about half the states have that now, and you've been involved in probably a dozen of them or more. Tell us about that, that case.
Yeah, that's right. So the case is called the Paxton case. And what the Supreme Court did recently is they validated that states can have age verification policies to regulate access for kids getting pornography. Now, if we kind of look at to really understand what they did and why it's important, we need to go back and think about what is the history of state regulation of pornography. Mm-hmm. And so let's kind of just give some clarity regarding laws related to pornography. Here's the thing to start with, and this is where I start with and where I encourage your listeners and lawmakers to start to think about. Pornography has never been protected speech. Pornography has never been First Amendment protected speech. So that's to say that there is not really a right to look at pornography or to sell pornography or to make pornography. And that's where I'm starting. Now, the attorneys who are out there, they're going to say, wait, Jameson, that's just not true. We have all these Supreme Court decisions that say that there's a First Amendment right to pornography. And I would say, no. Let's hold on and let's look at what the founders thought. And I'm going to read a quote from John Adams. John Adams is the first vice president of the United States. He's the second president of the United States. He's one of the major founders. So let's look at what John Adams says. And he starts by talking about the Bible. This is what he says. The Bible contains the most profound philosophy, the most perfect morality, and the most refined policy that ever was conceived upon earth. It is the most Republican book, meaning by Republican, he doesn't mean Republican Democrat. He means like that we are a republic, not a democracy. So he means like good government. It is the most Republican book in the world, and therefore I will still revere it. The curses against fornication and adultery, and the prohibition of every wanton glance or libidinous ogle at a woman, I believe to be the only system that ever did or ever will preserve a republic in the world. Now that's an old English. Let's unpack that just for a minute. What he says regarding pornography is this: the curses against fornication and adultery. Okay, so let's just start there. At the time of the founding, fornication was illegal. It was illegal, and that's something pretty recent that the Supreme Court struck down laws related to making fornication illegal. But let's just set that aside. Adams says the curses against fornication and adultery, and the prohibition of every wanton glance or libidinous ogle at a woman, I believe to be the only system that ever did or ever will preserve a republic in the world. So what's a wanton glance? He means looking at women lustfully. That's what it's libidinous, not libidinous.
Mm-hmm.
Libidinous ogle, like looking at women inappropriately. He says that we need to ban these things in order to preserve our republic. And this is something that George Washington says something similar in his farewell address. He says that we need religion and morality in order to preserve our government, to preserve our way of life. But here, Adams is talking specifically about pornography. He's talking about looking at women lustfully. And if we look at the history of the United States, and this history was cited in the Paxton Supreme Court case, I'm going to just read directly what the court said. They said, history, tradition, and precedent recognize that states have two distinct powers to address obscenity. Now, we'll talk about that difference between obscenity and pornography in a minute. But they say that states have two distinct powers to address obscenity. They may prescribe outright speech that is obscene to the public at large, and they may prevent children from accessing speech that is obscene to children. So those two things, the court can make obscenity just illegal, straight up, and they can also regulate access to obscenity by kids. And then the court goes on to say, by the 18th century, English common law recognized publishing obscenity as an indictable offense. So too did early American decisions. By the end of the Civil War, most states had prohibited obscenity by statute, and Congress had prohibited sending obscene materials by mail. And if we go into it, we could see 1821, the Supreme Court of Massachusetts. They upheld a conviction for a man who was publishing what they call lewd, wicked, scandalous, infamous, and obscene printed books. We see another law in Vermont, 1821. They made obscenity illegal. Connecticut, 1834. Massachusetts, 1835, codifying that previous Supreme Court decision, so that we had basically in 20 states laws that prohibited obscenity prior to the Civil War. Okay, so there's a long, long history of making obscenity and pornography illegal in the United States. Now, again, let's get back to what the attorneys are going to say. Jameson, you don't know what you're talking about. The Supreme Court of Massachusetts was talking about obscenity. When we were Vermont, they were talking about obscenity, not pornography. Okay, all of this is based on a trick, and this is the trick. Beginning in the late 1950s and in a landmark case in the 1970s called Miller, the Supreme Court came up with a new distinction between pornography and obscenity. If we look at that, just the language of that Massachusetts Supreme Court case, what did they say was illegal? Lewd, wicked, scandalous, infamous, and obscene printed books, okay? All of those things. Right. And at the time, there was no distinction between pornography and obscenity. The best way I could think about, how do we think about this, is this. Okay, at the time of the founding, let's compare pornography to carbon dioxide, okay? So at the time of the founding, the founder said, look, carbon dioxide, this is an example, by the way. I'm not going all green on you, okay? Just an example, but let's say comparing pornography to carbon dioxide, the founder said all carbon dioxide is illegal. It's all bad. But then in the late 1950s and into the 60s and 70s, basically preparing the way for the sexual revolution, the court started to say, well, okay, it's not all CO2 that's bad. It's just the C. The O2 is fine. And they made this artificial distinction between pornography and obscenity. And so now what the court says is, well, yeah, of course, obscenity has no First Amendment protection. It's never had First Amendment protection. But then they say, oh, but this thing called pornography, which the court just completely created out of thin air, making this distinction between pornography and obscenity. Now they say, oh, no, but pornography is legal. Obscenity is not legal. No First Amendment protection. Pornography is legal. Now, what happened in the Paxton case, the court said that pornography Obscenity is already illegal, whether it's
right.
adults or kids accessing it. The court said states can regulate pornography and they can use age verification to prevent kids from getting access to pornography. Okay? So they're starting to go back toward this basic understanding in which pornography and obscenity are thought to be the same thing. Now, let's kind of recap. What does all this mean, for your listeners, for your lawmakers? It means this. Pornography should be illegal. Pornography was illegal at the time of the founding. Pornography, and let's forget this artificial distinction between pornography and obscenity. Pornography at the time of the founding did not have First Amendment protection. Pornography should not have First Amendment protection. It should never have First Amendment protection, and this is why. There's really no distinction between pornography and prostitution. A lot of it involves human trafficking. A lot of it involves the abuse of others. It should be illegal. It is degrading to people. But most important, this. Pornography is offensive to God. And if we think about public policy, it's very important to make this distinction. While human beings are free to offend God, we can sin, we can do all the things, whether it's looking at pornography, whether it's cheating on your spouse, whether it's sodomy, whatever it may be. We can do all those things, but we do not have a right to offend God. We do not have a right to do these things. So in the big scheme of things, there is no right to pornography. There is no right to same-sex marriage. There is no right to fornication and to sin. There's no divine right to it. There's no natural right. We say in the law, the judges will say, oh, no, you have a right to it. But that's not true. In ultimate reality, there is no right to offend God. If we would go back to that principle, I think we'd have a lot of clarity for our public policy, and lawmakers would realize that they can do a lot more in terms of regulating pornography than what they are doing now.
This historic discussion is wonderful because it reminds me of one of my favorite quotes of all time. There was a guy by the name of Fisher Ames, and Fisher Ames was a congressman. He didn't live a long time. They offered him the presidency of Harvard University, I think age 47. His health. But what's interesting about him is he was a founding father. He was a congressman from Massachusetts who actually carried the First Amendment through the House side when they were ratifying the First Amendment. So, and you think about all the things that have happened to our society under the First Amendment as the left defines the First Amendment. But his quote was, "The known propensity of a democracy is towards licentiousness, which the ambitious and the ignorant confuse with liberty." And that's what I think is happening in our cultures. We think, well, liberty means we can do whatever we want, but our founders drew a line between licentiousness or license, which is a word we don't use anymore, unfortunately, and liberty. And the two are not the same because our founders wanted morally ordered liberty, not wickedness and licentiousness. And today, people are like, well, I can do whatever I want because I'm in America. And even pornography. I can do pornography as long as kids don't see it. And that's one of the major problems we have is we're confusing freedom with immorality, I think, in our culture because we can't draw the distinctions anymore. And so I'm glad this court at least gave us that limited line, and a small line, because we have to protect children first, because there's consensus there. But what might be the next steps for states? One of the things that came up this session after we passed that last session, and it passed in our General Assembly in Indiana, and some other states have done this, but it passed one chamber and then kind of stalled out for some legal questions. And that was the idea, okay, now that we can say that pornography sites have to use age verification, what about parents having to be notified when their kids sign up for internet apps if they're minors? Is that something you've heard of before? Was that unique to Indiana? I thought maybe one other state had done that. And is that the step in the wrong direction, right direction, or is that too little, too late?
Oh, no, I think that it's never too little, too late. I think we need to move forward with these things, which are very common sense. Louisiana just passed legislation about a month ago or so, requiring age verification for apps. This is something that AFA has been working very hard on using shareholder resolutions. We have been going to Apple, for instance, saying, hey, kids are not really protected in the App Store. You need to have some form of age verification, some form of protection. So we've been trying to work with these companies to pass common sense policies, but they are refusing to do so. Okay, so here's kind of some of the next steps for lawmakers to think about and for the general public to think about. Yes, we need age verification for app stores. We also need age verification for social media, and we need also safeguards for social media. These are some of the things that that big tech is opposing. And I want folks to just listen. Very basic safeguards big tech opposes. Number one, they do not want for minors to be notified. They reject requirements, let's say legal requirements, for parents to be notified if a minor has contact with an adult on a platform. Okay? So your child, let's say your child's playing one of these very popular video games, they're contacted by an adult. The tech companies do not want the parents to know about that. Okay? They want to conceal that. They don't want any kind of parental consent or parental notification. A lot of video games, let's say you're playing a racing video game, and you can earn better cars or something like that by racing, but to get the really good cars, you have to pay for it, bucks or whatever it may be. And kids are begging their parents, but maybe at some point the parent, they plug in their credit card or they do it through their phone or whatever. These micro transactions run into the billions of dollars. Tech making a ton of money from this, $1, $2, $5 that your kids are charging through these video games. The tech industry does not want parents to know when their kids are making these micro transactions. Other safeguards, they do not want parents to have consent regarding social media. So here's the thing. Parents need to recognize that they are not in the driver's seat regarding these video games. They are not in the driver's seat regarding social media. The social media companies and tech companies are not only turning kids into products, basically they're mining their data and all that. They're turning kids into addicts, and there's all kinds of studies that show when kids access social media, video games, all these things, there's this big dopamine rush. And this is, we're not just talking about, it's closer to hardcore drugs than it is to sugar. Let's just say that. Okay, social media is not good. Video games are not good for the developing mind of kids. And then third, the tech companies just don't want parents involved. And this is kind of what we've seen in the classroom, that parents have pushed back. Public schools have said, hey, we don't want to be in charge. When your kids go online, it's the same attitude of the tech companies saying, we don't need any parents here. Keep out. Parents need to assert their rights, and legislatures around the country, they need to move forward with requiring these basic safeguards for kids when they go online. I mean, again, we're talking about really common sense stuff. Like I said, notifying a parent when an adult contacts your kid online. I mean, really? That's something they oppose? It's very telling.
One of the things I thought was very telling during our debate, when we passed our law last year on age verification for minors, the nation's largest pornography distributor, and I won't name them, but you know who they are, rather than follow age verification guidelines for Indiana, they pulled their servers completely out to where nobody in Indiana could view that, because they didn't want to comply with protecting children. They just backed out completely. Now, to me, that's not a bad thing, but it tells me what their intent was. Their intent was to get young children addicted to this stuff, and that was a part of their business model. And I think other companies are doing the same thing, like you said, with social media, with legitimate things, games, things like that, because they know the addictive nature of this. But it opens the door for access to children that could be very dangerous.
Yeah, and I think the courts are reconsidering some of this. We just saw, for instance, a law out of Mississippi that was upheld, at least allowed to go into effect by the Fifth Circuit Court of Appeals, and that requires age verification for social media. Again, okay. Louisiana passed a law related to age verification for the App Store. I think just as with pro-life laws, you're going to see some laws that are upheld by some courts, and you're going to see some laws that or enjoined by other courts. But what that means is that state legislatures need to keep trying. And I think one thing that the Supreme Court was impressed by is all of the states, it got to be 16, 17, 18 states or so that passed age verification laws for pornography websites. The more that states pass these laws, the court will realize, hey, there's something to this. And the court is responsive to that. So I think it's very important to keep moving these bills, moving this type of legislation, and moreover, the type of dialogue that we can start to have. Like, hey, maybe social media is a problem. We see other countries that regulate these things. For instance, in China, pornography is illegal. I mean, imagine that. But our enemies know exactly the buttons to push to, as you said, how do we destroy the American Republic? Well, we basically eliminate the liberty and licentiousness. We get people to be really confused about morality. That's how we destroy the republic. That's what the founders said. I think some of our political enemies are well aware of that, and they play a role in pushing some of this stuff, TikTok, whatever it may be. They understand, hey, let's push this. Even though in their own countries, these things are illegal. But we need to have a lot more debate and dialogue about these things, and we need to have good bills that pass in legislatures like in Indiana.
Well, I know you're busy. I so much appreciate your time today. You're flying out pretty soon to Indiana. I look forward to meeting you and seeing you again. And you're going to be speaking to policy leaders from across the nation, probably some state legislators too, about religion and morality. I saw on Thursday, and by the time this airs, it'll be Friday. But give me maybe 30 seconds on what you're talking about in Indianapolis yesterday for those watching today.
Yeah, so I kind of alluded to this, but there is a long string of Supreme Court decisions in recent years, beginning essentially in the early 60s and anticipating and basically leading to what's come to be known as the sexual revolution. A long string of Supreme Court decisions where the court started to say, hey, just because something is immoral, just because something is sinful, that doesn't mean it should be illegal. And so they opened the door to a lot of confusion and misunderstanding on these things. And they directly departed from the American founding as far as the regulation of immorality goes. And so I'm going to be speaking to that topic and thinking about creative ways that policymakers can use to support morality. Again, if basic founding documents like the Northwest Ordinance, it says that religion and morality is necessary to good government. I think we take the founders at their word. They didn't say this is a nice thing to have. If you want to be more profitable, you should have religion and morality. If you want to have peace in your country, have religion and morality. No. They said, and it's interesting that they say both. Religion and morality is necessary for good government. And so I really take that seriously and think about, okay, what does that mean and how do we bring that back into public policy? How do we pass laws that uphold religion and morality so that we can recover our country?
Well, I know somebody's going to say, well, but you can't legislate morality. That is so not true. Someone's morality will be legislated. The question is, whose morality gets legislated? And that's why I'm so glad that you're a part of the political process. You're out there advising legislators and activists and policy leaders. So thank you for the work you do for righteousness' sake and for good public policy. And again, look forward to seeing you soon. And thank you for joining us today. Our guest is Jameson Taylor with the American Family Association in Tupelo, Mississippi, our national headquarters. And we just thank you for the work you do. And all my best to my friends down there in Tupelo.
Yes, sir. Thank you, Micah.
Good to see you. I hope you enjoyed that today. Give you some background on the bill that we've talked about a lot over the last 2 years. But thank you for joining us. I'm Micah Clark with the American Family Association of Indiana. I hope you have a wonderful weekend.